I was going to say good morning, may it please the court, but I guess we've managed to make it into the afternoon, lunchtime. George Vaca with Vaca Law Group here on behalf of Mr. and Mrs. Sanchez. We're asking this court to reverse a summary judgment that was entered by the trial court in the Sinkhole case and to remand the case for a jury trial on the issue of the appropriate scope of repair of the subsurface remediation efforts. At the outset, I'd like to do two things. First, reserve 5 minutes for rebuttal if I could, and second, make clear, if we haven't done so in our notice to the court, that the above ground issues have been totally resolved. So issue 2 in our brief is moot. And really the only thing that we're talking about here is the remediation plan for the below ground. I don't mean to belabor the point. Mr. Sanchez did not get a chance to participate in the Roker case, but I think Roker is on all fours. It's almost virtually identical policy language. It's the same motion that was written by the same defense team, and it was the same basis that the summary judgment motion was granted in the Roker case, which was recently reversed less than, I think it was 10 days ago, by this panel of this court. What struck me in getting ready for this, Judge LaRose, was I didn't think that you and I had been such constant travelers on the same Sinkhole highway during the course of time that these cases were going on. I was sitting there thinking, I was talking with Mr. Sanchez, thinking, never in my wildest dreams did I ever think that I would be known for cases involving sinkhole insurance, but I suspect maybe you have a similar outlook on life given the fact that you authored Warfel and Herrera and were involved in this one. I don't want to belabor the point on any of these matters. I'm prepared to argue about the meaning of the statute or the meaning of the policy if the court would like me to do that, but I don't really want to waste your time. I know that we're here at lunchtime. Roker seems to me to be 100% on all fours, and this panel of the court would seemingly be compelled to follow it. So unless the court has some questions for me, I'll be seated. Thank you.
Thank you, Mr. Vaca. So how are you going to get around Roker?
May it please the court. Well, obviously, I find myself in the odd position of coming to oral argument. I think it's 11 days, but after an on-point.
That old authority?
Yeah, that old authority. Admittedly, it's on point and it's adverse to my position. But I would begin by citing no less authority than John Belushi in Animal House. Was it over when the Germans bombed Pearl Harbor? No, and it's not over now. And so what I'd like the court to do is to consider what I think is going to be the arguments that Judge LaRose and the panel from Roker are going to hear on a motion for rehearing. And also and I understand that a PCA is not precedent, but clearly the Lantier case, which was cited in the initial brief as one that was essentially identical. And this is identical to Lantier, it's identical to Roker. It's the same language, it's the same, the players, the experts, I think, are all the same. And, Judge Kelly and Judge Kuzam and Judge Vellante affirmed that case. So at least I think it's reasonable to suggest that there's some difference of opinion within the second district on this issue. And I would suggest that it's also not surprising. I mean, sinkhole insurance and sinkhole claims are very difficult. I mean, it's a pain in the neck. That's why the legislature has been wrestling with this for years, tried to fix it in 2005, tried again to fix it in 2011, because you've got a very unusual group of circumstances. You've got a loss that's invisible, it's under the ground, people necessarily have to guess how to fix it. It's not like a hurricane or a fire where you know what the cause is and you know when it happened, and it's not progressive and you can put the fire out, they continue, a lot of difficulties. So what they did is create a statute in 2005, which I think everybody can agree is not a model of clarity. It creates some problems. I think it's fair to say it's ambiguous at best and maybe even contradictory. So what they did is, I think this is what the legislature was trying to do, and what I want to do is talk about what they tried to do and a way to read the statute where you can harmonize all of it. What they tried to do is say, what we are going to do is take the adjusting process away from the insurance company and put it in the hands of an expert. And we are essentially going to dictate how these claims are going to be handled. And the first thing is, we're going to make you hire an expert that's licensed, that's responsible for a professional opinion that they're going to give. We are going to make you do testing under 7072. And it says the expert is going to do testing. Clearly a reference to the expert that's hired mandatorily by the statute. Then the expert, singular, will write a report that talks about whether or not there's a sinkhole, and if there is, how to fix it, and how much it's going to cost, and those kinds of things. And then, if they're wrong, then you might have to pay twice. If they start fixing it and it goes wrong, you don't get credit for, if you get a $300,000 policy and they put $250,000 worth of grout in the ground and it doesn't fix the house, you may have to buy the house anyway. So you've got a shot at fixing it. But then, of course, not only do they do that, but then they create a neutral evaluation statute to try to resolve differences on these issues. So is there a way to read this statute? And this is something that's perpetuated in 2011 too. It's going to be confronted by this court and the other DCAs as well. How do you reconcile this idea of this initial mandatory procedure where an expert picks the way to fix the thing? They've got to sign a contract because the legislative intent is fix the houses, use scientists, and reduce litigation. How can this court read that statute in peri materia, harmonizing all the provisions, and give effect to this legislative intent? And what we would suggest is that, simply put, is you have to give the initial engineer's process a chance. You have to give it a shot to work. So what you do is you require the initial repair to be done in accordance with the original engineer that's identified, that does the 7072 testing, that writes the 7073 report, sign the contract that comports with that original plan, let it happen. Now, the question then you're going to ask me is, but what is neutral evaluation for? Neutral evaluation still has a function. First of all, there's an entire category of cases that are denials. In denial cases, the neutral evaluator comes in and says, okay, this expert says that there's no sinkhole, this expert says that there is a sinkhole. You go to neutral evaluation, maybe it resolves it. If not, neutral evaluator testifies at trial. Happens all the time. The second function of neutral evaluation could be the cost. There can be a wide range of costs with regard to the plan issued by the original engineer. Let's say the engineer, like in this case, says grouting, compaction grouting, no pins, just grouting. Well, I mean, you can have the dollar store grouting company come and do it for X number of dollars, and maybe the insured wants the Ritz-Carlton grouting company perfumery to come in and do it for $1 million. That is something that NE can come in and arbitrate that on a non-binding basis, and if it doesn't get resolved, goes to trial. And that is a way that the insured could get a result that's more than what the neutral evaluator says or what the insurance company is willing to pay. So that gives effect to the neutral evaluation process. Here's another purpose of neutral evaluation. Remember, we've got this safety net for the insureds, where if the original engineer says it's going to take 150 cubic feet of grout to fix the thing, and then it turns out that's not enough, it's like a brand new policy gets opened up and they can't have to pay again. Well, a neutral evaluation gives some pretty good advice to an insurance company. If I'm an insurance company and a neutral evaluator says, guess what, guys, this is insufficient, you're going to wind up pumping 150 grand into the ground, and then you're going to have to dump your policy limits on top of it. That's a pretty useful way to get rid of a case before it goes into litigation. And an insurance company should think long and hard when a neutral evaluator says that, to not maybe pay limits and cut and run because you can't fix the house for policy limits. So there is that safety net there. So that is three real functions of the neutral evaluation procedure. It also is true, it gives effect to the entire statute. And in fact, in this case, As Mr. Vaca pointed out, when the first part of the issue 2 was resolved, the Sanchezes have already signed a contract based on grouting, the BCI method of repair, and done the grouting. Why not? Why wouldn't it be consistent with the statute to let that happen? Because what the result of that is this. It comports with exactly the aim of the statute, both the 2005 and the 2011. We have a universe of claims. Instead of every one of them going into litigation with a war of the experts right off the bat, let the first protocol be done. Sign the contract, do the repairs. Now the house is fixed or not. They've avoided litigation in, let's say, 80% of the cases. Because remember, one of the reasons that the legislature brought these experts in is because they have experts. They have professional responsibilities. They're issuing opinions. So they have an interest in their professional reputation and their malpractice exposure to get it right. So let that have a chance to work. And if it doesn't work, you have what you'll get rid of 80%, 90%. How often are the engineers going to just malpractice? It's going to eliminate a huge universe of cases where people don't have to go through litigation, don't have to hire experts, don't have to wait 2, 3, 4 years to get their houses fixed. The house gets fixed. And for that small percentage, I would submit, where it doesn't work, if it starts cracking again, well, then it's revisited. You have these actions that we're seeing in a small amount of cases, but they're out there, on failed repairs. You also have actions, and these actions are including actions against the engineer. Because at the end of this process, the engineer has to seal the plan and say, this thing is fixed. And if it's not fixed, there's a remedy. So this is not, it's not at all a my way or the highway situation. There are 2 safety nets, one within the process, and then possible litigation later. And that's when you could have another neutral evaluation on the failed repair. How do we repair this thing? Do we pump more grout? Do we do chemical? Do we underpin? Then you have a much smaller universe of cases that are being litigated. You have a lot of houses that get fixed without litigation, and you have scientists making the decision. So I would submit that an opinion from this court that affirms the summary judgment, but recognizes this possible reading of the statute would be entirely consistent. It would create a roadmap that would really be a service to the plaintiffs and insurance companies, because it would create a pattern that realizes the aims of the stated legislative history of it. It would create order out of chaos. It would follow the law, all of it. It would preserve the safety nets, because look at the alternative. If you litigate first how to fix the house, what does that do to the safety net about reopening the policy? We go to trial and the court says, no, we believe Mr. Galati, and we believe that pins are appropriate. Well, what happens if they put pins and they break the house, they break the foundation? Now should the insurance company be forced to reopen its policy to pay for when the court has decided Mr. Galati's way is right? It removes a protection from the statute and is inconsistent with the statute. By allowing the first engineer's plan to go forward and giving it a chance to work, it avoids that problem. The added bonus, it avoids this paradox where insurance companies are being found guilty of breaching contracts when they are step by step by step following the contract, following the statute, yet they're somehow being found guilty of breaches of contract. I mean, it's very hard to think of another example of where you follow the letter of the law and the letter of your contract exactly, yet you're still in breach. It has an added bonus. An opinion like this would have an added bonus. This court, in the next few years, because they're going to come down the pike, has the 2011 statute. Look at the changes in the 2011 statute. They make it explicit that it is the insurance company's chosen expert that dictates the initial repair. The neutral evaluation statute is still there. So this court in the 5th and the 1st DCA, or probably this court in the 5th mainly because that's where the sinkholes are going to have to reconcile these 2 aspects of the 2011 statute. We would submit an opinion that recognizes this, let it have a chance to work, would not only resolve a huge problem with this present statute, but it would anticipate how the 2011 statute works. And then you don't even have to get into the issue of, was the 2011, is that a clarification? Because it'll work for both. It'll solve a problem, It'll reduce litigation. People will fix houses. Scientists will make the decision, and every case won't have to come through the courthouse. And for that reason, we ask this court to write such an opinion and help us all out, and maybe Mr. Vaca and I can quit doing sinkhole cases for a couple of weeks. Thank you.
Mr. Sanchez.
You know, I appreciate the very eloquent plea from my colleague, Mr. Samus. But for the conduct of his client and the conduct of its lawyers before this case got to this position, maybe his request for some type of an advisory opinion might be appropriate. Or perhaps if Mr. Samus had been advising the insurance company from the beginning as opposed to trying to fix what they did at the end, maybe it would be appropriate for that. But Mr. Samus told you that the clients did everything that they were supposed to do under the contract, and yet they're getting sued for breach of contract. But if one looks at the very provisions that are in the policy that they actually issued to my clients, you will see a couple things. First and foremost, there is a provision that there is some dispute as to whether or not this provision is or is not in the policy. But if you accept their position that this provision is still in the policy, which is the optional sinkhole loss endorsement, and you go to Section 3 conditions, it talks about, in the event of a sinkhole loss, that the insurance company will pay for sinkhole loss subject to certain restrictions, and then says we will pay no more than the actual cash value of the damaged property, not including underpinning and grouting, or any other repair technique performed below the existing foundation of the building, until you enter into a contract for the performance of building stabilization or foundation repairs. What did they do? They were submitted with a contract by FTE was the engineer, Champion identical. Champion was the people who were going to do the repairs. They rejected the contract, paid no money, and said, as they did repeatedly, not only in this case, although this was Royal Palm later taken over by Tower Hill, but in all of these Tower Hill cases, would they say, no, you have to enter into a contract for the repairs as recommended by our engineer. Not what their policy says, a contract, our contract. Once you enter into such a contract, we will pay the amounts necessary to begin and perform such repairs as the work is performed and as expenses are incurred. Yet they never did that. They refused to pay anything on the Champion contract. So I appreciate that in the grand scheme of things, if we could redo everything, Mr. Samus could come in here and ask you to do something differently than what the facts are, and we could try to envision what somebody meant by the statute. But the bottom line is, what he's asking you to do, what the grand scheme now is to, one, give a presumption of correctness to their expert's report, which the Florida Supreme Court has quite clearly said, and Your Honor wrote a decision before the Supreme Court did, that said there is nothing in this statute to suggest that the burden should be put on the insured to disprove what the insurance company is saying. This is an all-risk policy. It's the burden on the insurance company to prove that it's not covered. They want to flip that prospect on its head in their utopian way of how this statute's supposed to work. No contract, they refuse to do it, they refuse to pay until they entered into a contract like this one. There is absolutely no difference in this case in Roker, or any meaningful difference. We've had this discussion. We can talk about what 2011, I suspect when addressing the 2011, we'll be talking about unconstitutional presumptions like the Supreme Court referenced in its decision in Warfel. But that's for another day. This is a 2010 policy and a 2010 loss. They refused to accept the contract. They didn't pay and refused to pay. And that's precisely opposite of what they said in their contract. So this summary judgment should be reversed. It should be remanded exactly the way it was in Roker. And we would ask this court to do so. Thank you.
Thank you both very much.